dealing with the things you can and cannot do. The ideal of this session is just to kind of keep you on the straight and narrow. The last thing we want to see is any of you work so hard and end up messing up and end up before the State Office of Administrative Hearings, dealing with the State Board of Examiners of Marriage and Family Therapists. These are the individuals, there's 9 of them, by the way. These are the individuals that deal with y'all and the issues that y'all have that may come up. So as I was looking through it, I noticed that Kellyanne had asked a question, and that question had to do with what areas of the law other than TerraSoft have to deal with us when it relates to record keeping, confidentiality, release of records, and required reporting. And I think Kellyanne really wanted to know, like, you know, where out there in the world are we going to have to be careful? And I know for you guys, other than the obvious stuff, which is the relationships with your clients, one of the big deals has to do with who asks you for information, who can you give it to, who claims those privileges as it relates to the client's records, the files, and that information. So instead of going into every single one of them today, I told Sarah that what we were going to do was cover one section. And the reason why I only want to cover one section is because it turns out that there are multiple areas of the law that have to deal with y'all. And when I say multiple areas of the law, I mean, you're looking at the Texas Family Code, you're looking at the Occupation Code, we're looking at the Government Code, the Texas Health and Safety Code. And these are all codes that were created by the legislation and are codified under different areas of the law. And primarily what we're going to deal with today is the Texas Administrative Code. So just to start off, under the Texas Administrative Code, I was taking a look at it. The parts that y'all are more concerned with for y'all, and I'd really advise every single one of you that is going to go out, open your own practice, or provide any therapy to anybody, to take a long look at it. Look, some of it is a bunch of legalese, and you're probably going to have an attorney sit down with you, not because you lack the knowledge to be able to figure it out, but there are just so many cross references when it comes to information and so many exceptions because it's just not straightforward. But you're going to want to take a look at the Texas Administrative Code, particularly for you guys, the parts of 30 to 36, as it relates to LMFTs, LMFTAs, LPCs, LSWs, LSOTPs. Those are the sections that deal primarily with that part of it. Now, I know that there are other type of mental health therapists. That's not covered under the Texas Administrative Code. That's covered elsewhere. So, like I was saying, who are you worried about? Who are you concerned with? Because at the end of the day, as an attorney, I have to answer to the State Bar of Texas. If I get in trouble, I go to Austin and I deal with them and we have full-blown hearings. Well, for mental health professions, like in any other profession, nurses, doctors, y'all actually have a board that you deal with, and it's the same way. That board is located in Austin, Texas. They are the oversight board when it comes to y'all. And typically they have a hearing once a month to take a look at people that have committed acts that they shouldn't have done. So today, for now, I wanted to go and just dive in, and we're going to talk about, it's going to be Title 22 under Chapter 801, specifically record keeping, confidentiality, release of records, and required reporting. Under that section, there are 2 things that are extremely important, and that's communication and the patient. Obviously, the patient, it is anyone that you're providing therapy sessions to as it relates to diagnosis, evaluation, or treatments. Communication in the code, which I thought was a little interesting because communication has to deal with communication between the licensee and the client, right? And for them, it's a little odd because it talks about communication in the sense of recordings. Any diagnosis, evaluations, and treatments that you actually put down in paper and you record in any way, any medium, whether it's recording live or recording on paper or making notes about it. What I found odd about that is it didn't say anything about verbal, because as attorneys, any verbal communication is qualified as communication and it's subject to privileges. For y'all, I didn't see that in your code, which I thought was a little odd, but if I was in your shoes, I would consider it the same thing, and I would keep that confidential as well. So when you're talking about confidentiality, one of the first things we look at for you is who can you not disclose any communication with? And when it comes to the communication, what are we talking about? We're talking about the records, the identity, and the records and the identity of the client. right? Obviously, we know the records include the evaluation, the diagnosis, and the treatments, and the identity of the client as well. You cannot disclose those things. However, like in any good area of the law, it's never black and white. There are exceptions on exceptions to that rule. One of the major exceptions for you guys, and we'll go over that in a minute, is the Texas Health and Safety Code, Chapter 61, relating to mental health records. In addition to that, there are other state and federal statutes and laws that have come out of courts that also are exceptions to that. And in the context of Chapter 61, what we're really going to talk about, and I'll get to that right here in a minute, is information that you can release outside of administrative and judicial proceedings. And that is when some third party comes to you and asks for the information, including your client when they ask for information. So under that chapter, it's who you cannot disclose to. Now, the other area of that is that you must comply with the Texas Health and Safety Code as it relates to Chapters 81, Mental Health Records Privacy, the Texas Health and Safety Code, Mental Health Records. And again, this is concerning the release of information, medical health records, and client information. So some of the areas that I'm just going to highlight them real quick, where you actually have to release information, you're required to release information. This is obviously going to do with areas that y'all are going to become familiar with, unfortunately. Under the Texas Family Code, Chapter 261, it's relating to investigation and reporting of child abuse or neglect. So what I was going to tell Sarah is that section is just huge. There are so many exceptions in that section, and it's just voluminous that I would like, if maybe in the future, to go over that, because I could see how each one of you may at some point in your career have to deal with that if you're dealing with children or if you're dealing with the family unit as it relates to people involved in the family courts. Another area that you must report or release information is under the Texas Human Resources Code. That's going to be Chapter 48, and that's relating to the investigation and protective services for elderly persons and persons with disabilities. Now, the Texas Health and Safety Code under Chapter 161, Subchapter L, is relating to the abuse, neglect, and unprofessional or unethical conduct in healthcare facilities. Now, the Texas Civil Practice and Remedy Codes for mental health professionals, just like attorneys, with the exception of a small area of it, you have to report if you know if someone else is being a bad actor. I call it a bad actor because to me, that's just the easiest way to remember it. But that's a section that you would probably want to take a look at in your own free time. And what that has to do is with the sexual exploitation by another mental health service provider. So if one of the fellow professionals you find out is doing something that they're not supposed to do, you're under a duty to report that within 30 days to your bar, to the council, or to the district attorney's office. Actually, the way the code reads is you've got to report that within 30 days to the DA, to the licensing agency, whoever that mental health service provider is licensed under, as well as counsel if you are a licensee. Now, I don't know if y'all have covered this or not. I'll make it quick because I don't want to be redundant or cover something you've already covered in your ethics class. But before you tell any of those three individuals, you have to tell the victim that you're going to report. And you have to ask the victim if they'd like to stay anonymous or if they would like to actually be known who they are. What you're going to report is the name of the alleged professional that's committing the bad acts. If the individual wants to stay anonymous, you're not going to report them. If they don't want to stay anonymous, you're going to have to give the information. And then also you have to let them know who you are and how you're licensed. So just make sure when you're doing that you do that within 30 days. And the reason why you want to do that within 30 days is because at the end of the day, you can actually face discipline, probation, things of that nature for not doing your job. It's very similar for us. We're not allowed to know about certain acts that other attorneys commit and then not tell. Because think about it like this. At the end of the day, all of you have a duty to make sure that each one of you is putting the profession in a good light. All right, so under the Texas Health and Safety Code, there's a section titled 7 Mental Health, and it's mental health and intellectual disability. Subtitle E, provisions relating to mental illness and mental retardation. One of the things I found interesting in that section is under the definitions, they had patient, but the other part about it is who is a professional. Obviously, it's a person authorized to practice medicine in any state or nation, a person licensed or certified by the state to diagnose, evaluate, or treat any mental health or emotional disorder. I was telling Sarah that one of the things that I found odd about this section is that actually it applies to people that the patient reasonably believes is authorized, licensed, or certified as provided by this subsection. Of course, the certification part, that's not, that's obvious. It's the part that a patient believes is reasonably authorized. The reason why I bring that up for you guys is because the section that we just got through talking about, I'm sure y'all covered in ethics, but in that section, it tells you that you have a duty to report people, right? Well, if someone reasonably believes that another person is a mental health service provider, and in fact they're not, you're going to need to report that. In the practice of law, we come across, oddly enough, frequently individuals who engage in acts that are considered the practice of law, and we have to report that. So just be on the lookout, and I don't even know if that's a good way to put it, but make sure you pay attention to that, because if you have a client that comes to you and you find out the person that they were seeing isn't in fact a mental health service provider, that duty is placed on you to make sure that you report them. And God knows, what kind of harm they've done to the individual at that point. So under section 611.002, we're talking about the confidentiality of information and prohibition against disclosure. There are two exceptions when it comes to disclosing information under 611, and those two exceptions fall under 611.004A and 611.005. So under those sections, under the 611.004A, people that can request that the information be confidential or the information be released is obviously your patient. The other person is the parent, if the patient is a minor, and someone who represents the patient, any representative of the patient who the patient has given actual consent to. Now, I'm going to jump a little ahead in that section. When an individual comes to you and says, hey, look, I am the guardian or I'm the caretaker of this individual, and they said that I can release that information. First off, you need that consent in writing. You need it dated. In addition to that, as y'all are practicing in your field and people start asking you for information and release of information, realize that when you're talking about mental health records, just like when you're talking about medical records, just like when you're talking about files as a lawyer, the request needs to be very specific, and you only need to release to the extent of the request. Because at the end of the day, if they say, hey, I want the entire file, you guys know that that file may contain all kinds of information about other people. So you're going to have to be very careful that that information that you release is tailored to the information that requested, or it's up to you, and that duty's on you to ask them, well, what specifically are you asking me for? In addition to that, not just what specifically you're asking me for, the other thing is, why are you asking me for this information? And then when you release that information, it's up to you to make sure that these individuals only use that information to the extent that it's needed, and to limit it as much as possible, and to keep it safeguarded. Now, the code doesn't really talk about how you can make sure these individuals do that. I'm sure that you can put something in place, but just make sure that when individuals are coming to you and they say, hey, I represent such and such, that in fact, at the end of the day, that it's in writing and that there's some proof. One of the big things I was looking at here, just because I'm an attorney, is that when somebody comes to you and says, hey, I'm the guardian of, of Sally or Joe, and I'd like their information released, and here's their consent. Well, you need to take a step back and think about the person that's asking you for that information. Just because I come to you and say, hey, I'm the representative of Sally or Joe, and I'm the guardian, what proof do they have? If I was you in your practice, I would require them to get you a court order or something from the court that says that they are actually the guardian. And before you release that information, I would go back and check that with the district clerk's website in whatever county you are in. Majority of that stuff will be there. If you cannot find it, because sometimes it's considered sensitive data and we don't release that to the public, you can always talk to an attorney who can take a look at it, because you don't want to be releasing information to an individual that's, being fraudulent or being deceptive, because let's be honest, guys, we're all old enough here now that we know people like that in the world, and those things have kind of happened before. Okay. So just make sure that you realize that. When it comes to, sorry, I have some notes here that I'm looking at. One of the other things.
To hold questions for the end, or can we jump in?
Sure, go ahead.
I was just wondering, when you were talking about the childcare neglect, concerns for the elderly and disabled people, and also you mentioned if we had concerns about somebody not being a mental health service provider, if we just had suspicion, or do we need to have that? That was my, like, where's the line between suspected child abuse or suspected concern about a mental health provider not being who they say they are? Or do we need fact? Like, when do we report these things?
Okay, so that's I didn't delve real deep into the Texas Family Code because, like I was saying, that is a voluminous section. However, I have dealt with that before, and I have perused that section. Luckily for you guys, you just have to have a good faith belief. As long as you have a good faith belief that you can actually articulate, then that duty is on you to actually report it. And the really good thing for you guys is, at the end of the day, is that if you have a good faith belief and you can articulate why you believe these things are going on and that you need to report it, there is an exception to the rule that even if you've done it on accident, and let's say the information that you had turns out to be something completely different, and the child isn't being sexually assaulted or abused, or the elderly person isn't being neglected, you misunderstood them, there is a section in the code that actually protects each and every one of you. And if you think about it, that's extremely important, because we want mental health professionals to come forward and release that information, because you may be the only person that they're telling, and you may be the only person that can put them in a situation that at some point they can get help, and that the individuals that are committing these bad acts against them can be prosecuted. Okay, so good faith. It's good faith that you can actually articulate.
Great.
And like I said, maybe one day I'll come back and talk about that section, because that section is huge. Because obviously, as each one of you would probably assume, at some point you're probably going to be pulled into the courts to deal with one of those issues. And in fact, I was going to tell you in the beginning that more likely than not, you will probably come in contact with the court system at some point in your career if you're dealing with any kind of individuals with issues at all. Okay.
Yeah, thank you. I just was trying to clarify the suspicion over having evidence of these things.
Sure, no problem. So one of the big questions, I think, for you guys is, who claims the privilege of confidentiality? Well, I think it goes without saying, it's presumed that the professional, each one of you, is allowed to claim the privilege of confidentiality. It's the physician-patient relationship, the mental health service provider relationship with the client. So you can claim the confidentiality and the privilege on behalf of your client unless there's evidence to the contrary for that consent. And what I mean by that is that if a client comes to you and says, hey, I'm going to allow you to release this information, you can't use the privilege or the confidentiality, and here it is in writing who you can release it to. You can depend on their information. But again, it's one of those situations where it's a CYA kind of circumstance. In our practice as a lawyer, it's to write everything down, document everything, just in case there's ever an issue. When I have clients that issues start arising, I make sure that I double time it. And I mean by that is that every single phone call, every text message, every email gets documented somewhere, just in case there's ever an issue and I have to be called before the State Bar of Texas. Other individuals, the patient obviously can claim the privilege of confidentiality. Now, with that being said, there is exceptions to that when it comes to the patient, and that has to do with you guys being able to withhold information, and I'll go into that in a little while here, because that can actually result in litigation. But as the healthcare professional, even if a patient comes to you and asks for information, you're allowed to deny your patient any access to their information. You can tell them, hey, look, I'm not going to give it to you, but you've got to be specific in why you are not going to give it to them. The other people that can claim the privilege of confidentiality is the parents of the minor, as well as the guardian. Again, just the guardian, sorry. Just make sure that you're on your P's and Q's when it comes to those things. You don't want to have issues in the future. Now, let's talk about authorized disclosure of confidential information other than in a judicial or administrative proceeding. So this is in your typical everyday life. This isn't the court saying, hey, release this, we're dropping a subpoena on you, you need to comply with it. No, this is outside that realm. And if you give me 1 second, I'm actually going to go over those with you, each one, because I think that section to me was extremely important. And there's like 11 subparts of it. So these are the people that you're allowed to release information to. You can disclose the information, and this does not relate to a judicial or administrative proceeding. The reason why that's the case is because judicial and administrative proceedings are different. The power of the court and the power of me to issue a subpoena and make you produce is exponential. These other individuals here are pretty limited. Now, the courts in family law settings, in criminal settings, your entire file can be requested, and the judge can make you turn over every piece of paper that you have in that file. And I'll talk a little bit more about that in just a minute here as it relates to that. So when it comes to the authorization disclosure of information, you can release it to a government agency if the disclosure is required or authorized by law. So again, you're looking back at the other sections, the occupational code, the Texas Health and Safety Code, and the other ones that I've mentioned to you, the Texas Civil Practice and Remedies Code. To a medical or law enforcement personnel, the professional determines that there is a probability of imminent physical injury by the patient, to the patient or others, or there is a probability of immediate mental or emotional injury to the patient. You're really going to want to remember that. And the reason why you're going to want to remember that is because that is an excuse to either release information or to provide information. If the individual, if there's an imminent physical injury by the patient, which for us, imminent means more likely than not, you'll have to make the decision as time goes on what that means to you. And that also relates to their mental or emotional state. And you're protecting the individual themselves, and you're protecting society. You can release it to a person who has the written consent of the patient. The patient is a minor, so the parent or a guardian, like we talked about, the patient's personal representative. This is an interesting one for y'all who are going to go out in the world and actually open your own office. You can actually release the information as is necessary. Remember, again, you're going to want to tailor the information you're releasing to people. So if you have an accountant or you're an individual, a corporation, or government agencies involved in paying or collecting fees for your mental or emotional health services provided, you can release information to them. However, again, you're going to limit the kind of information that you're going to release because you're only trying to accomplish a certain goal. You can release it to other professionals and personnel under the professional's direction who participate in the diagnosis, evaluation, or treatment of the patient. So obviously, if two of you are working on a patient's case together, you can share that information between one another. To an official and legislative inquiry relating to state hospital or state school, and that's in the situation where a individual with mental health issues may be admitted to one of these places. Correctional facilities, juvenile facilities, or an employee or an agent of one of those places. But one of the things that you have to pay attention to is that they're only going to, one, be released the amount of information they need. You want to limit it again, and that they're going to take the appropriate steps to protect that information. So one of the things y'all want to do when you're in your practice every day and people come to you, whether it's a state agency, whether it's an individual or a representative of your patient, you want to ask them, how much information do you want? And then you want to find out from them, how are you going to protect this information so that it is not released to the rest of the world? Because we can imagine how damaging this could be to any of your patients. If you have to satisfy a request for medical records or a deceased person, or one of the other interesting areas is that if you're dealing with older people, is if it turns out they've become incompetent, you may end up in probate court. Well, you only need to release the information to the extent that it has to relate to their cognitive ability and their mental health ability to make decisions and things of that nature. And typically the courts are pretty good about saying, hey, we only need this much. You don't have to tell us the rest, okay? Anybody have any questions regarding that? I guess not.
Question. I did have a little question, Josh. I didn't want to be the only one asking questions. If we have concerns about parents, and you said that we're obliged to give information to parents because of a minor. Mm-hmm. Yeah, we're allowed to release information to the parents of the minor, but we have concerns about the parents.
So that's actually a really good question. Honestly, that's a great question. So here's what you can do, and I'm glad you asked that because I did want to really spend my time on that with you guys. you have the ability at the end of the day to not provide the information to the patient, to the parents of the minor, as well as to any guardian. And that's extremely important, because what you're going to want to do is you're going to want to make sure that information is written down, meaning, okay, this is what the client has asked for. This is what they want. However, because I believe that this will cause them some kind of physical harm, mental or emotional harm, you can turn around and deny it. And what you're going to want to do is tell them, listen, I'm going to deny your request for that information, whether it's the parent, whether it's the patient, whether it's some third party, with the exception of the ones that you have to disclose to. And you're going to put in very detail, I'm denying it for these reasons. And the reasons typically are based on some physical harm to themselves, some physical harm to the community, some mental or emotional harm to the individual. And you're going to want to sign that piece of paper. You're going to want to date it, put your reasons why. Not only are you going to put a copy of that in your file, but you want to tell the patient and give them a written copy of it as well. Now, realize that the patient has remedies to that, or the individual requesting information from you has a remedy to that. What they can do is either one, file in the district court in your county, in one of the courts in Harris County, in the district court, not the county court at law, but an actual district court. Or if they're, let's say the individual was treating with you and now they live in another state, well, then they have to file in a district court in Austin. That deals with all of that stuff. Now, the real question about that comes is, all right, let's say Kellyanne or somebody else in this group denies that information and tells either the patient, the parent or guardian, or this third party, hey, I'm not giving you this information. Here's why I'm not giving it to you. I'm not going to give you a lot of detail, but in my file, I'm going to keep really good detail of it. Well, the aggrieved party has a cause of action. And what they will end up going and doing is saying, hey, look, I'm going to file on you because these are my records, right? We could see a patient saying that. This is my stuff. I want it, and I want it now. So they go to the district court and they hire an attorney. You bear the burden of proof on why you denied that information. And that is not something along the lines of, well, hey, I kind of thought. No, you need to be very specific. You need to have taken great notes, and you need to be able to articulate why you're denying that information. And if you end up failing that burden, because the burden is on you to deny it, if you fail that burden at the end of the day, that individual can sue you for penalties, meaning they can seek monetary damages from you. And I don't know how that part goes because I haven't seen it, but yes, they can ask you for money, and they can ask the court to award money for you not providing them information. So just make sure that you're doing a really good job, guys, in putting that information down in your file, okay? I guess everybody understood that. So one of the other areas in which you specifically are allowed to release information, it goes without saying, in the legal fields, we're not allowed to release any information on our clients either, unless it's under certain circumstances. And those circumstances actually apply to y'all equally. If another healthcare professional, mental health professional is asking for the information so they can treat the patient, well, you can give them that information because obviously now they're going to be the new mental health care provider. In the other areas that you are allowed to release the information, and always keep in the back of your head, when you're releasing information, you're only releasing enough information in order to meet whatever requirements that exist to the extent necessary. If I have a situation where my client says, hey, look, you represented me in this property lawsuit and I'm not going to pay you. Well, I don't need to release all the information to the court to say, hey, these are all the issues that I address in this property dispute, and this is what was going on. No, I need to show the court, this is what I build, this is why I build it. These are a heading of the topics that we discussed, the hearings that I had to address. That applies to y'all equally. If you are sued for malpractice, to the extent necessary, you can release information regarding your client and the mental health services you provided. If you have a patient who's complaining and you're dealing with a license revocation before the board, you can release information to the extent to protect yourself and the extent necessary to show that you did your job. If you're in a judicial administrative proceeding and your client is giving you a waiver, then you can release that information. Just make sure if your client is giving you a waiver, again, make sure that it is narrowly tailored to the point that needs to be addressed, consistent with just enough information to get what you need to accomplish. If you are collecting money and they haven't paid you, you can release that information, again, to the extent necessary to collect the money for the claim for services, which I wouldn't be surprised if y'all run into that issue. We run into that issue every now and then. Honestly, a rule of thumb, I just eat it. I don't want to go down to the courthouse and argue with my client who owes me money unless it's an extremely large sum of money. I'm not doing it. I'm not putting my clients in that predicament, and I don't want to be up there talking about everything I did, because that just becomes just no bueno. At the end of the day, if I was you, if it's not a whole lot of money, take it to your accountant, show your accountant it's a tax write-off. In a judicial proceeding, there are certain documents that are privileged and not privileged. Depending on the type of case you're dealing with, will depend on what information you have to release. Now, there are a couple of proceedings in which you're going to release everything. A suit affecting the parent-child relationship, if one parent is claiming, hey, this child's been sexually abused or neglected somehow by one parent, at the end of the day, more likely than not, you're going to release that entire file. In criminal proceedings, there is nothing that you get to keep. When I have criminal proceedings that involve these type of acts, when it relates to children or elderly people, we file motions and we literally get every single thing out of your file. And I'm going to talk to you all about that in just a second here. And again, in probate cases, if it has to do with any mental health issues. If your client is revoking a consent to release information, make sure it's written, date, and signed. If any of you thought about it, which you probably should have, if it's a smart client, the smart client's going to turn around and go, hey, I'm revoking your consent to release any information about me because we're in the middle of a dispute and you're collecting money from me. Well, under those circumstances, the client cannot actually revoke consent. The consent stays with you because the client can't use it as a sword and a shield at the end of the day. Anyone have any questions about that? No?
Okay, just to be clear, so you're saying in any criminal proceedings that if they wanted to do the revoked consent that you can't, like, yeah, I have to release the information point blank period. They cannot take that back.
That's right. So in a criminal proceeding, and I'll talk just a little bit about this. I don't want to take up too much of your time. I know this stuff might be sounding a little boring. In a criminal proceeding, I'm going to ask for everything in that file. I'm going to ask for all of your notes. I'm going to ask for your background information. I'm going to ask questions about you. And I'll talk a little bit about this at the end because that's my favorite section, because it's the section I deal with. Guys, everyone on here, whatever you do, make sure you do your job and do it well. Make sure you take lots of notes because you want to cover yourself. In addition to that, don't ever put anything in the file. And this may go without saying, but you would be surprised. Don't put anything in the file that may reflect on you as an individual. I know lots of mental health professionals get into this field because of issues that they've dealt with in life and now they want to help. I will say that's a double-edged sword at the end of the day. You want to do it because you want to help people because of something that may have happened in your life. Whatever you do, make sure that the people that you're telling that to are, that it's kept in confidence, that it's another mental health professional. Don't talk to your family about it. Don't talk to other people in your workplace about it. Only talk to another mental health professional. The reason I say that to each one of you is because at the end of the day, I'm going to be able to ask you questions about that stuff on the stand. And you can imagine if you're coming in and the state of Texas has subpoenaed you to show up to testify about your knowledge and however you treated this child for the sexual abuse or the neglect that they've experienced, I'm then going to turn the tables on you. I'm going to use the bad things that have happened to you to show that you're actually not neutral in this situation and that you've coached this child or you've led them down the wrong path. And that may sound horrible, but that's the job that I have to my client in my profession. And it's my job to look through these things and get all that information out. So I'm glad you brought that up because I was going to move on to judicial proceedings. There are three types of subpoenas that you guys may encounter at some point during your practice. Those type of subpoenas is a witness subpoena. That is, hey, we're sending this to you, you receive it in the mail, you need to come to court and you're going to testify on whoever subpoenaed you. And maybe the court subpoenaed you. That typically doesn't happen. The court may write off on a subpoena, and typically they do in the criminal setting. But in the criminal setting, it's either going to be the prosecutor or a defense attorney that files a subpoena and asks you to come to court to testify. Another type of subpoena is a subpoena ducis tecum. A subpoena ducis tecum says, hey, I need you to produce notes. Typically in a court setting, you're going to get a witness, you're going to get a subpoena for yourself to show up and testify, but you're also going to receive a subpoena ducis tecum. And that subpoena ducis tecum is more likely than not going to say, hey, produce all your notes, any information you have on this individual. In the criminal setting, you're going to have to bring all your notes. I'm going to ask for all your notes. The prosecutor is going to ask for all your notes. You're going to bring them all. In the family law setting, it's slightly different. There are exceptions. So again, when you're looking at your information, look at what they're asking and find out, well, what do you need the information for? Because that might limit the type of information in the notes that you bring. The other area where you may get a subpoena is a subpoena in a deposition. We need you to come, down to an office and we're going to depose you and ask you lots of questions about the case. In a subpoena and a deposition, and even in other situations when it comes to subpoena, you can always reach out to an attorney and say, hey, I've received a subpoena and I'm not sure that I should be following along or answering it or providing any of these records, and here's why. What the attorney will do is turn around, review it with you, and then file a motion to quash, saying, here are my reasons why you can't call this person as a witness. Here are the reasons why they should not produce their notes. And here's the law that protects them from doing so. A motion to quash, in essence, says they don't have to show up. They don't have to produce these records. And we have hearings on those. So I just kind of wanted to talk to you guys a little bit about how this works in the family law sense. And before I wrote some notes down. And I talked to 2 different family law judges that are on the bench now, and one's a former family law judge. This is a spill outside of the law. Not everybody respects your area. I'm sure y'all have heard it referred to as a soft science. So what you will have when you walk into these courtrooms, on one hand, is judges who don't respect what you do. You're going to have attorneys who have egos who don't respect what you do. Believe it or not, you're going to have jurors in the veneer panel who don't respect what you do. And what I mean by that is that they don't believe in it. So my advice to you is do your job, do it damn well, keep lots of notes, continue your education, because at the end of the day, each one of you is an expert. You are an expert in your field, and you get to walk into the courtroom, and you should know more than anyone in that courtroom about the area that you practice in, the modalities that you use to treat these patients, and why it's legitimate, because that's what they're going to attack. They're going to attack your education, your training, and they're going to attack the legitimacy of the basis of the scientific theories that relate to that and how you apply them. Because at the end of the day, if you're going to be considered an expert in your area, they're going to look at the foundation of your practice field. They're going to look at how that's supposed to be applied. Then they're going to look at you as an individual and determine whether you applied it correctly. And trust me, as attorneys, that's the area that we love. I love doing a 702, 705 Kelly Daubert challenge, because what will end up happening is, in a family law setting, you're going to get called to court. Maybe mom or dad hired a therapist and they turned around and they hired you and you did all this stuff, and they bring you into the courtroom and you're getting ready to testify. Well, after you're done providing a certain amount of information, I'm going to stand up and say, Judge, I'd like to take this individual on a cross-examination on direct voir dire. And I am immediately going to talk to you about your education and training and explain to the court why it doesn't apply in this situation. Then I'm going to turn around and go, even if it does apply, you obviously lack the ability to understand the basis of it and how to apply it without, whether it's you applied it wrong or whether you weren't neutral in applying it. So some of the tidbits I got from the judge, and I'm just going to be honest with you, this particular judge is not fond of mental health service providers in her courtroom. And in fact, she says that for the most part, she never liked using them when she was on the bench for like 12 years. She just doesn't have a lot of respect for them. The reason why is that she felt that when people in your field were called in to testify, they were used as a tool. They rarely ever got both sides of the story because they were just treating either mom and the kiddo, and that they could see a lot of coaching going on. Those are things that you have to be concerned about. I understand that y'all are dealing with an area that is extremely emotionally driven, and you want to probably reach out and help the person, the child, the adult, whoever it may be. When you're getting ready to testify in court, you're going to have to come from it from a neutral perspective. Yes, you need to advocate and you need to provide this information, but you also need to be neutral so that the jury, and the judge can take a sit back and go, hey, this person knows what they're doing. They know how to do it, and this is why they did it. And they really took a big view of it and looked at the forest and the trees. Any questions regarding that? No? Okay.
It's good to know, Josh. Honestly, that's like really useful information. I just hadn't thought of that kind of that kind of attitude. I just thought people were not questioning our science of family therapy. So it's really useful.
It's unfortunately sad. I have actually represented individuals with mental health issues, learning disabilities in courtrooms, and I can tell you based on my experience, I remember very, very well, I had a client that I represented, and of course I can't give you his name, but I can tell you slightly about the background of that client. And that client had extreme anger issues, but it also had to do with the things that had happened to him in his life. It had to do with him being bullied as a kid. It had to do with his parents not really reacting correctly under the circumstances. And one day, out of many times, he got really, really upset. His parents had like 3 huge flat screen TVs in the house. And he went through the house and took each one of them and beat them with a hammer and destroyed them. So the parents called the police. The police came in. The kid was charged with a number of crimes, including like resisting arrest, hitting a police officer, which ended him up in a felony court. I talked to the prosecutor numerous times, and they just did not care about the mental health issues. So every now and then when I have a case that I see issues in, I will impanel a group of people. Sometimes I pay them, sometimes I don't. 6 to 12 people, I bring them in a room and I present information to them. And we keep the information pretty minimal. But believe it or not, out of the 12 people that we talked to on that case, 9 of them were just like, we find it as an excuse. We find these outlashes, the emotional outbursts, just as excuses, especially as it relates to children. And you guys really need to know that when you're going to court to testify on these things and dealing with these issues, a lot of people are going to be adverse to you. They really do believe, especially in America, Kellyanne, they believe at the end of the day that kid just needs a good, for a lack of better words, that kid just needs a good ass whipping. I've heard that so many times, that the lack of these children to behave and do what they're supposed to do is because parents are not harsh enough on them. Parents aren't spanking their children like they should. It's that old school mentality. If you beat them with a belt and you keep them in line and you rule your family with iron fist, they're going to do well. I really do believe that the mental health profession is only starting really to come around, and we're really starting to actually address that, hey, beating your kid isn't always going to be the answer to the problem. But in your courtroom, you're going to find that a lot. So that's something that y'all are going to have to deal with if you ever have to go to court. Hopefully the attorney that helps you out really gets you there when it comes to those issues. Which brings me to my next topic, is therapist as a helper. In the family court setting, at times when there's reunification of a family or there are issues going on, some judges will actually appoint a therapist to help with the children. Just make sure that when you're dealing with that you're not being singular, and that you're looking at the overall family unit and you're dealing with the family as a whole. Because what they want to see is counseling for the child. They want to see it for the family. It is extremely effective. And it typically is dealing with reunification settings, because at times you will have situations that have just gone so bad that the child is taken out of the home, lives somewhere else, and then at some point, the parents will then petition the court to get the child back. and the court will typically want to have a mental health care provider involved in all that. Good? Yay? No? Everybody's being really quiet and used to questions. So I wanted to talk to you guys a little bit about sexual abuse cases, because at some point, if any of you are thinking about becoming a licensed sex offender provider, or if you're thinking about dealing with children in the sexual abuse setting, you may end up at the Children's Assessment Center, whether it's in Harris County, Montgomery County, or Fort Bend, or pretty much any county that you will work in. They have a CAC, which is the Children's Assessment Center, and they deal specifically with children that make outcries, which that is another thing that you guys should worry about in your profession. The child may come to you and tell you, hey, I've been abused in one way or the other. Well, that makes you the first point of contact. That makes you the first outcry witness. And that's literally what we call it. It is an outcry witness. And in every single case, that either if it has to do with custody or it has to do with prosecuting the perpetrator that committed this offense against this child, you're going to be called in to testify regarding that, because you are the first outcry witness, and that is the most important person in that situation. So the way it typically works is you will have an outcry witness, whether it's at school, whether it's with their mental health provider. That individual, whether it's you or the school, will turn around and they will make a call. And that call is typically to the police. And the police will then turn around and call the Harris County District Attorney's Office or the Fort Bend County District Attorney's Office, or whatever county that you're in. They will call that District Attorney's Office. What they will then turn around and do is, whether it's the police officer or the DA, will say, hey, make sure you get to the hospital. You'll go to the hospital. They will do a SANE exam on the child, which is for DNA evidence and other information. And they do an intake where they get all this information from the child about what happened. Then that child and the parent or the guardian will have a meeting set up with intake at the Children's Assessment Center. The Children's Assessment Center will bring the child and the parent. And I absolutely disagree with this, because I've dealt with it a lot. They will bring in the child to the CAC. And I'm going to back up. The reason why I disagree with this model that they use when it deals with children that have been sexually abused or neglected is that they bring the child in to this facility. In the facility, there's a therapist there, there is a lead therapist, and there's always a police officer or two. The child and the therapist, just like you guys, will sit in a room, and the lead therapist will stand outside the room, and there's a glass pane that they can see through, but the therapist and the child cannot see the head therapist and the police officers. The police officer and the head therapist are there to guide the therapist in the room and find out the information about what goes on. If any of y'all are ever thinking about working in the CAC or a facility like that, please reach out to me. And the reason why is because I feel like you're wearing two hats. And I might tell you not to go down that field and do that, simply because at the end of the day, they make the child recall every single bad act that happened numerous times over and over and over, as opposed to working with them slowly and trying to help them heal. They are there just for investigative purposes. And I truly don't believe they necessarily care about the child, because they actually don't ever provide therapy. They'll send you somewhere else, but they will call you in to testify regarding all that information. So with that being said, if anybody has any questions, great. If you don't, thank you for the opportunity. I am so sorry that I talk so much. There is a lot to cover. So yeah. If I can leave you with anything, guys, make sure that you do what you're supposed to do. Cross your T's, dot your I's, and take what you do seriously, because we're not going to cut you any slack when you walk into a courtroom. And at some point in your career, you really will. That's all I have.
Thank you, Josh. Does anyone have questions?
It was super informative. Thank you so much. I really appreciate your time.
You're welcome. I'm sorry if it was boring, or if I said like 50 times.
No.
No.
All right, y'all have a good day.
Yeah.
Thank you.
Thanks.
Thank
Bye.
you.
Thank you so much.
You're welcome.
So for anyone who doesn't know, that's my ex. He's my daughter's father. So I had to like turn it off so I didn't make faces at him, my camera. But okay, so I wanted to share with you guys some upcoming events real quick.
Well, while Sarah's doing that, today's Wednesday. Tomorrow at 11, we partnered with the UHCL Wellness and Recreation Center, and we're doing for the public a mindful meditation. This week is actually mental health or mental illness week. And I believe the official observing day is this Saturday for mental health. And so as we bring that in for FTSA, we decided to do like a standing in solidarity event for the university. And so you can look at that at the UHCL Rec website, also on our Instagram and Facebooks. We have the links on there as well. It is a Facebook Live event too, so for anyone who is not maybe a UHCL student just yet, it would also be on there.
How do we get to it? Is it on a Zoom meeting or we have to go through Facebook?
So you could either do Facebook if you want to do the Facebook Live event, or if not, if you go to UHCL Rec, and so it should be, we have the links on there, but if you go to the UHCL Rec, the event, you can sign up and they'll actually send you the link because they're doing it virtually. But if anyone who, they're also doing social distancing too, so our instructor will be up there. I'll be up there tomorrow as well at 11 to do a socially safe and distanced yoga. But it's also virtual too for anyone who wants to do it in the safety of their home.
Thank you for explaining that.
I'll resend the link for that out.
Yeah, would you? That'd be handy. It was only the other day I could find it, but and I guess we'll have our mics off, so if there's kids in the background, it's okay. They won't.
Oh yeah. Mm-hmm.
So yeah, that's tomorrow, October 8th. And then for Delta Kappa members, we have the induction ceremony on the 20th. And then we are going to have a virtual happy hour at the end of the month, just because a lot of us need some of that social connection that we're not getting. October 25th, we have a pizza fundraiser at Maud. It's going to be the one on Bay Area. And we will send out information to you guys for each of these events too.
Mm-hmm. And that will take out as well. You can do takeout or you can sit in, but yeah.
And then our next speaker is November 4th. Corey, you want to talk about that one?
Yeah, so she's actually our guest speaker for November. She is an alumni from here. Also, she opened up her own private practice. So Jenny Dietz, she actually specializes in eating disorders, body image, and self-image struggles. And so we're gonna have that event open to, of course, our members and then UHCL community for anyone who wants to partake in that. But she'll basically just be answering questions on how to kind of cater to patients where there's common themes around like intense emotions, attitudes, and behaviors regarding weight and food. So that should be really fun.
Mm.
And then November 7th, we'll have the emotionally focused therapy training, and that is a Saturday, and it's going to be starting at 9 a.m. It's, I think, about 6 hours. That includes a lunch between this first and second session or section, and that's Zoom as well. And then we'll have a holiday party November 20th. That's tentative, just depending on what is going on with everything COVID related. And again, information for each of these things will be sent out to each of you. And I will send this flyer out to y'all after this meeting.
Is there any charge for the EFT training?
There is.
Yeah.
Yes. I don't know.
Be.
I can't remember what it is. Members of FTSA and Delta Kappa get it at least 50% off, because if you go and do it on your own, it's, what was it, 370?
It was close to 4.
Yeah. So you will, it's going to be, I forgot, what did we say?
I'm trying to see if I have my notebook with it here.
Just a ballpark, Chandler, like 50 or 200, like roughly.
Oh, I think it's less than 200.
Okay.
I know that much. But I think if you're not a member, it was like 125, I think. And then if you are a member, I think we
It's
were either, yeah,
it's
it was,
under that, like
yeah.
100 or less. Something.
But honestly, if we get an EFT certificate, that'll be amazing.
You
Yeah,
do.
so
So you will get a certificate at the end of this. So
That's super
you'll
duper.
take a quiz or a test after. You'll
Mhm.
have a link where you can take a test, and then you'll get a certificate emailed to you.
And who's doing it? Is it the people in Montrose, the EFT clinic?
No, it's something provided by Sue Johnson. So it's a DVD set, and we'll play it on Zoom for you guys.
Her institute. Lovely.
And then we'll have
Super.
breakout rooms where we can practice that stuff.
And anyone who's not familiar with EFT, emotionally focused therapy, it's a really big evidence-based model to be using with couples or any relational dynamics that could really, really help. Last year we did the Gottman training, which is very valuable therapy model as well. But this year and the way the climate of everything going on, we felt that EFT would be a little bit more beneficial in this particular setting. So if you know anyone also who is interested in that, which is a great model, I really love it. I'm biased on it. But yeah, we can let them know.
That's all we have. Anyone have any questions?
Don't we have maybe January too, motivational interviewing?
Yes, I was only doing November, October, November, but yes, we'll have Mary, who's a second year. She is certified in motivational interviewing, and she's offered to give it to us, the members. And so for members, it's going to be, I think, is it $5? Like that. And then
yeah, really valuable tool. You can use it with like substance abuse patients and just any client if you're trying to gauge their motivation for change. So that should be really good too.
And then in your, I think, is it second year or third year, we'll be doing the substance abuse class. And the book we have is the motivational interviewing. And so this will kind of get you a head start on what you'll be learning in this book. I've had it for like a month and read 5 pages of it. So I'm hoping I can get more out of it so that by the time the class rolls around, I'll know what I'm
Start packing your clinical tool belt.
Yes.
Stuff in for you.
Dr. Hall keeps telling me, since I'm seeing clients, that I need to read it because it helps. And I just, with everything else, I can't just read another book. It's hard right now. So anyway, that's, we also are going to have the, sometime this month, maybe early next month, depending on how everything goes, renting out for members a theater auditorium so everyone can come and relax. It's up to 20 people, so it's just going to be for members, not families, because you have to adhere to social distancing. But that'll be paid for by me, and then you guys can come and just get your own snacks. We can talk. Fun little thing to do just to unwind a little bit.
Why are you paying for it?
Because I was going to do it
Okay.
anyway. I don't want to sit there alone, so yeah, invite people.
Well, we can talk about the payment because that doesn't seem fair.
Anyway, anyone have any questions? Anything? No? Okay. So